Well, a senior advisor to President Trump taking to Twitter this weekend to urge a primary challenge against House Freedom Caucus member Justin Amash of Michigan. Senior White House advisor and director of social media Dan Scavino tweeted this, quote, "Real Donald Trump is bringing auto plants and jobs back to Michigan. Justin Amash is a big liability. Trump trained to defeat him in primary." Well, President Bush's former chief of ethics counsel, Richard Painter, tweeted back this. Ethics 101, you can't put official titles and WH White House photos all over your personal Twitter page and use it for partisan politics. Hatch Act. So is that a violation of the Hatch Act? Let's bring in criminal defense attorney David Bruno, Fox News legal analyst Mercedes Cohen on this. Mercedes, is this the tempest in the teapot? Or, I mean, a no-no. You shouldn't do this and use White House rigmarole for something that's political.
It's a tempest in a teapot. Frankly, it's very clear. There's no intent to engage in this type of discourse, to influence politics in any way. It's his personal Twitter account.
Influence politics. He's calling for a defeat of a Freedom Caucus
No, but this
member.
is 2018. He's expressing it's one tweet, expressing his opinion. He's talking about the White House and what they've done so far, what POTUS has done. This has nothing to do with partisan politics. This is all about one single tweet, one opinion, nothing more than that.
But when you say partisan politics, you mean on an official account.
Exactly right. I mean, it's his personal account. So that's going to be a real challenge for anybody who's going to step forward and say that somehow he's violated the Hatch Act.
But David, apparently on his personal account, he had like what, photos of the White House and
not a problem.
Flags and, you know.
No, not a violation of the Hatch Act. Okay, Hatch Act prohibits the executive branch employees from having political activity on the job or using the official title. And in this particular tweet, it is a Twitter account that is not official. He doesn't use his official title in the tweet. It's on his personal. You know, in addition, there's also some guidance from the Office of Special Counsel, who's the agency that's responsible for enforcing this. And in a frequently asked question publication, it even says, note, that the inclusion of an employee's official title or position on one social media profile is not enough. Okay, so this isn't even an official profile. This is a personal profile.
Yeah, but look, Kellyanne Conway, she's on Fox and Friends, and she got demanded she get criticized for turning, you know, the White House press briefing room into the Home Shopping Network. I mean, she was talking about Ivanka's, you know, clothing line, and
it was literally a 5-second soundbite, and everyone went completely crazy over it. She was talked to, said, make sure you don't make that type of statement again. It was really a nothing.
So
there was no
what
issue
would
there.
be a Hatch Act violation that would be against the law as you see it with this tweet, or with a tweet?
If it's done on the job while someone's being paid by the federal government, or if they're using their actual title in part.
If it's their official Twitter account, if it's their official Twitter account through the executive branch, that's when it becomes exactly. It has nothing. If it's your personal account, there's no Hatch Act
interesting. Meanwhile, another controversy brewing in Washington. General Michael Flynn, you know, the president's former national security advisor. Well, he apparently wants immunity. His lawyer sent that letter asking for that to testify about Russia and the presidential election, and the Senate Intelligence Committee, at least for now, has turn that request down. So Mercedes, I mean, you know, people say, well, why would you ask for immunity if you're not guilty?
Any defense attorney worth their weight will say, we're not talking to the feds unless we get this type. We're going to give you a proffer, but we want immunity in exchange. Why do I say that? Because it's a crime to even make a statement, a misstatement to the federal government. So why go into that? Why step into a scenario where you can actually be charged with making a misstatement to the federal officials, as opposed to having done anything unlawful.
So David,
that's why the defense attorneys do it as a matter of course.
Okay, that's the criticism. Agreed. Like, what's he hiding? What's he hiding? It's wrong. It's a wrong perception.
Yeah, but it's consistent with the Fifth Amendment of the Constitution, and it is rule number one for a criminal defense attorney: do not let your client speak without those protections. And it's been rejected. You know, he's not getting it at this time, and we may see the next step is that he's going to be subpoenaed to testify, and in that case, he'll probably invoke the Fifth Amendment, and then the agencies are going to have to make a number of decisions whether or not they're going to compel his testimony.
That's an important point, too, David. The fact that he may invoke the Fifth Amendment, there is, per se, there could be something that could be going against him. Somehow there's some criminal activity that he's not willing to testify about. So invoking the Fifth Amendment at least has the specter that he was involved in some sort of criminal activity.
Well, if you have televised hearings, I mean, you know, the critics are going to be all over that.
Oh, completely.
Him raising his hand.
Completely.
You know, saying, they're going to say he took the fifth, took the fifth, took the fifth.
Exactly.
But the Fifth Amendment, you stand there and say, I evoke my right. It's my right not to self-incriminate, whether there's incriminating material or not.
What he should say is just say, upon advice of counsel, I have been told not to answer that question. Upon advice of counsel, just blame the lawyers, because when all said and done, blame the lawyers there. That's the best way to deal with that.
Absolutely, and it's ironic given his prior statements during the Hillary Clinton investigation, absolutely. But I would bet he didn't speak to a lawyer before making that comment.
So finally, what do you predict, David? You think that he could be called before a committee?
I think he could. He'll likely invoke his Fifth Amendment right, but let's not forget, if there's evidence that this individual has committed a crime, the government does not need his statement. They will look to the documents, they will look to the certifications, they will look to the wiretap communications.
Or the intercept of the of phone conversations.
Exactly.
The best evidence would be bring him forward, bring him in under subpoena. If they've already rejected the proffer, bring him under subpoena, ask those tough questions. If he invokes the Fifth, you have an adverse inference anyway. So those things can be used against him.
And you think the same thing would happen if he's, dragged down to the U.S. Attorney's Office?
Oh, sure. I mean, but only if they're rejecting the proffer, then they can ask him questions. He can just refuse to answer them. But the most important thing is he cannot make a misstatement to federal officials. Otherwise, it's a crime in and of itself.
But there are also other protections that can be had with the DOJ, with the United States Attorney's Office. They can give certain protections for statements also.
All right, well,
so there are many things the attorney could do here.
We will be interesting to see what happens indeed if at an open hearing, General Flynn sits down behind that defense table or witness table and sees what happens. Thank you, Mercedes and David. Fascinating.
Great to be with you.
Thank you.